Financial Services Modernization Act, also known as the Gramm-Leach-Bliley Act, was enacted on November 12, 1999. In addition to reforming the financial services industry, the Act addressed concerns relating to consumer financial privacy. The Gramm-Leach-Bliley Act required the Federal Trade Commission and other government agencies that regulate financial institutions to implement regulations to carry out the Act's financial privacy provisions. The FTC is responsible for enforcing its Privacy of Consumer Financial Information Rule, also referred to as the Privacy Rule. The FTC recommends that anyone who must comply with the Gramm-Leach-Bliley Act also review the Privacy Rule. The Gramm-Leach-Bliley Act is a large law that covers a variety of different aspects of the financial industry. For our purposes, we are going to focus on the privacy provisions of the law. The privacy provisions of the Gramm-Leach-Bliley Act restrict the disclosure of non-public customer information by financial institutions. In addition, all financial institutions must provide customers the opportunity to opt out of the sharing of the customer's non-public information with unaffiliated third parties. The Act establishes minimum federal privacy standards, but allows states to adopt stricter standards not inconsistent with federal law. Finally, the Act imposes criminal penalties on anyone who obtains customer information from a financial institution under false pretenses. A violation of the Gramm-Leach-Bliley Act may result in a civil action brought on by the U.S. Attorney General. The penalties include those for the financial institution of up to $100,000 for each violation. In addition, the officers and directors of the financial institution shall be subject to and shall be personally liable for a civil penalty of not more than $10,000 for each such violation. Criminal penalties may include up to 5 years in prison. If the Gramm-Leach-Bliley Act is violated while another federal law is violated, or if the Gramm-Leach-Bliley Act is violated as part of a pattern of any illegal activity involving more than $100,000 within a 12-month period, the violator's fine will be doubled, and he or she will be imprisoned for up to 10 years. Now let's take a minute to explore privacy notice requirements. Mortgage lenders, mortgage brokers, and mortgage loan originators collect a client's information through the following avenues: information on loan applications, information from credit reports, and information from other sources such as income and banking information. This information is considered non-public personal information and is protected by GLB. If a financial institution shares or sells this information with a third party for uses other than the original transaction, the financial institution must provide a detailed disclosure to the client. There is also the option of a sponsored mailing, in which a financial institution can send out a mailing on its own letterhead that endorses another company's services. For example, a mortgage lender and a title company agree to initiate some cooperative marketing. But rather than share client information, the title company agrees to send out a letter to their client base highlighting all the great services that the mortgage lender offers, as well as any specials they are offering exclusively to that title company's clients. This would be considered a sponsored mailing and would require no disclosures to the title company's clients, since it's within the agreement limits set up between the title company and their client base. During the original transaction, sharing non-public personal information with appraisers, credit bureaus, document preparation companies, investors, and wholesale lenders to process or otherwise complete a client's transaction does not require a detailed disclosure. However, a financial institution cannot share information or databases with these same entities for marketing purposes without prior consent from the client to do so.